Ready? Start. Besides the above documents and several others, including a letter of repudiation of the kind executed in the instant case, the parties also executed a construction agreement similar to the one which is the subject matter of the case in hand. Stop. While the purchaser brought a suit for specific performance, the sublessee plot owner filed an application under Section 20 of the Arbitration Act to enforce the arbitration clause occurring in the construction agreement. Stop. In the suit filed by the purchaser, the sublessee filed an application under Section 41 of the Arbitration Act. Stop. This court, while dismissing the application under Section 20 and 41 of the Arbitration Act, observed that it is a matter of common knowledge that in Delhi, due to various restrictions imposed on the owners of plots held by them on perpetual leasehold basis, they devise methods to dispose of their plots by entering into various documents, like in the present case. Stop para. The construction agreement is not to be read in isolation. Stop. I find when the appeals filed the present petition under Section 20 of the Act, they withheld material information from the court. Stop. They said nothing except the construction agreement. Stop. After written statement was filed, they in their replication admitted execution of various documents mentioned above. Stop. They said that agreement to sell was no doubt executed by the parties on 1/8/1978 itself, but said that the parties immediately thereafter discussed the matter the same day, and in view of the fact that such a contract was forbidden by law, decided to execute the construction agreement superseding the agreement to sell. Stop. This cannot be true. Stop. Para. Sir, same dispute at a subsequent stage again found its way to this court, that the plea of the plaintiff is that it was a sale by irrevocable power of attorney which was executed for valuable consideration, and an agreement to sell was also executed and full price was released. Stop. However, in view of the restrictions on the transfer contained in the lease, the property could not be conveyed by formal sale deed at the time when the agreement to sell was entered into, and a power of attorney was granted by the defendant in favor of the plaintiff against payment of full consideration for the property. Stop. Counsel for the defendant states that the power of attorney has since been revoked. Stop. I am unable to understand as to how any irrevocable power of attorney for valuable consideration could be revoked simply by a notice under law. Stop. Counsel for the defendant states that the said grant of power of attorney was accompanied by an agreement for construction of a building. Stop para. This argument is absolutely fallacious because in fact the transaction appears to be one of a sale by power of attorney, notwithstanding the lack of formality of the execution of the formal sale deed, which could not be executed in view of certain restrictions contained in the sale deed. Stop. Under the scheme whereby DDA has given the liberty to the plot holders to obtain freehold title, the position of purchases by sale on power of attorney has been recognized, notwithstanding the fact that such a sale could not be considered to be a sale of the property in the eyes of law under Transfer of Property Act. Stop. Learned counsel for the plaintiff next submitted that assuming the transaction was one of agreement to sell, the same is illegal in view of clause 6 of the perpetual sublease. Stop. Clause 6 of the construction agreement insofar as it is relevant to the case in hand. Stop.